Good morning, friends. We start today a series of lectures on military law. The first session covers introduction, constitution, and military law. The aim and purpose of this series is to acquaint and sensitize the students towards military law. It would help not only those who want to join the Judge Advocate General's Department of the Army or the other two services, but would also interest others who want to make a career in practice, litigation, or want to teach, want to take up reporting, or be an author on military law. The first session would cover the apart from introduction, the connection to the constitution and the structure. To begin with, what is the relevance of discipline to military? I would wish to highlight that military has to be combat ready at all times. One doesn't know when the military has to take up arms. Hence, there is a prime necessity for discipline amongst the rank and file. And therefore, the purpose of military law is to assist in maintaining good order and discipline within the armed forces. What are the special features of military service that set it apart from their civilian counterparts? Firstly, military service has a universal jurisdiction as opposed to the civilians who, while in service, are connected to a particular state or a zone, or those from the corporate sector who are connected to that company alone, its branches. Military service, one can be called upon to serve anywhere in India or beyond. The other point is voluntary induction. Nobody calls a person for military service from his home. The person who wants to serve has to come out and present himself for recruitment, enrollment, or a commission in the armed forces. Military, though it's part of the government, these are public posts, but there is no quota or reservation. And till very recently, women were allowed to serve only in certain portions. Now it has been slightly expanded, and amongst the officer cadre, women are part of the regiments and corps that are specified, and otherwise, traditionally, they were only in the medical services and the nursing cadre. It's also to be borne in mind that a soldier has no right to resign. What does it mean? It indicates that while induction is voluntary, one cannot separate from the military service on one's own. One can only make an application to resign, which may or may not be accepted. Next special feature is that military law is a self-contained code. There are special statutes like the Army Act, Navy Act, and the Air Force Act. And under the Army Act, rules have been framed, and all governance of the military is by way of this self-contained code. And lastly, the higher judiciary, the Supreme Court, and various high courts do not possess the power of superintendence over military law decision, subject, of course, now to the jurisdiction of the Armed Forces Tribunal, against which there is a statutory appeal available to the Supreme Court or to the High Court in case there is a matter concerning infringement of fundamental rights. I mentioned about the military law being a self-contained code, and the code refers to a statute and all the statutes which do not need or depend upon any other act, and they are able to exist, they are able to operate without external help or influence of other laws. And this aspect of help or influence is, say, with regard to the procedure, how the military courts operate, how a tribunal can be set up. It would proceed with its procedure, appeal, etc. It would be useful to be aware of the rank hierarchy in the army. There are three different tiers. There are officer cadre, then those below officers are the junior commission officers, which rank from a naib subedar to subedar major, and then there are persons below officer rank, in which there are sepoys, riflemen, gunners, etc., and they go up to the rank of havaldar. Insofar as the officer cadre is concerned, it starts with lieutenant, and then there are promotions to the next higher ranks of captain, major, lieutenant colonel, colonel, brigadier, major general, lieutenant general, and general. And you may appreciate that in the three services beyond the rank of general and equivalent, now there is chief of defense staff also, which is a post. The rank continues to be of a general or equivalent. On the slide, you see the badges of rank which are worn on epaulets on the shoulder of a subedar, where there is an Ashoka chakra, and then subedar with the two stars and naib subedar. Another special feature is about the concurrent jurisdiction. You would recall in one of the earlier slides it was mentioned that the High Judiciary does not have power of superintendence. Nevertheless, with regard to the jurisdiction, a soldier is subject to the jurisdiction of the law of the land, for example, Indian Penal Code, as well as the military law, the Army Act. And therefore, soldier in the country has the same rights and duties as a civilian, and therefore, consequently, he is also bound by the rights and duties under military law, and therefore, he stands subject to military law as well as the law of the land. Military code is regulated by this Bear Act, which is on the slide in front of you, and apart from this, by the Constitution of India. Then each service has its own acts: Army Act, Navy Act, Air Force Act. There is now Armed Forces Tribunal Act and the Defense Services Regulations. There are certain demands of military law which make it obligatory for all ranks to subscribe, to adhere to follow the law as laid down. And this would indicate that whosoever is at the hierarchy or on a higher position, in other words, is a superior commander, it becomes his responsibility to enforce discipline and also to administer justice. Now, these two aspects, to enforce discipline and administer justice, shall be explained to you in greater detail as we proceed with the different sessions of this military law series. And this would indicate to you that there is no separate category of judges to administer law. The trial takes place by a system of court-martial, which are ad hoc courts, and members of those court-martials are your own peers. So say an officer of the rank of major is to be tried by court-martial. So the members of the court-martial would be major or lieutenant colonel or higher rank officers. And trial proceeds on a day-to-day basis because of the urgency and necessity to maintain discipline. Matters cannot be allowed to drag on. Offenders in military law are not viewed as criminals. They are soldiers, and they may have deviated from the laid down code. code, they may have violated the orders, and for that action of theirs, they would be brought before a court martial, dealt with, but care is to be taken to remember that they are not criminals, they are basically soldiers who can be reformed, who can be corrected, and then again turned into useful combatants by giving them requisite punishment to bring them online. The other important aspect relates to command influence. Since the responsibility and duty to maintain discipline and administer justice is on higher commanders, therefore, there may be a scope for a criticism, alleging command influence. And command influence is a common criticism of military law in different jurisdictions across the globe where it is said that a higher commander yields an influence in decision making. The legal department of the armed forces is called the Judge Advocate General's Department. They are all officers holding a degree in law, qualified and experienced, and they are the legal advisors to the service head, which is Chief of Army Staff in the case of Army, otherwise Chief of Naval Staff or Chief of Air Staff, and their setup. And this body of officers who are legal advisors are known as Judge Advocate General Department officers. In this connection, I would invite your attention to the regulations for the Army, which are Defense Services Regulations, hence this abbreviation in front of you, RA and DSR, which indicates para 33 that the Judge Advocate General is the legal advisor to the Chief of Army Staff in the matters of military, martial, and in its fighting service aspect, international law. He also assists the Adjutant General in matters relating to discipline involving application of military law. Now, this provision, these 4 lines, may perhaps induce an idea that the Judge Advocate General is advisor in matters of military law. While this is so indicated in this para, but this is not really so, because he is the only legal advisor to the Chief of Army Staff, and therefore all issues, whether relating to military law or constitution, property law, or say family law, are referred to the Judge Advocate General officers for their advice. Having regard to the role of the Judge Advocate General Department officers, it would become clear that these officers must function with requisite amount of professional courage, and a soldier is also expected to show moral courage by accepting his guilt where it is so. This is part of the moral code. So what this is based on is the premise that anybody can commit mistakes. There may be bona fide mistakes, there may be deviation or a deviant behavior. Well, that is so, but it is expected that the soldier would stand up and accept his fault, his deviation, and that is what is the part of the moral courage. There are distinct modes to deal with an offense, which is quite apart from an administrative lapse. Now, these modes to deal with an offense could be administrative action, summary trial, there could be summary disposal, and lastly, the trial by court-martial. And there are 4 different types of court-martial. What is their composition? Who can convene them? What are the procedures and what are the powers? We would see in subsequent sessions. At this stage, I would like to make it known to you that court-martial can be perceived as a system associated with the military service where a single or a group of officers decide a case. Now, court-martial, in the case of summary court-martial, is headed by a single person, the commanding officer of the accused, whereas in other types of court-martial, there are a group of officers in odd number 3, 5, 7, and so on. They decide a case of law, which may be infringement against one or more accused persons on a specific charge sheet. Explaining this a little further, the court-martial may have before it only one single accused or a number of accused who in that charge sheet in relation to those offences that have been committed may have acted jointly, and therefore they would all be co-accused. Types of court-martial. There is a summary court-martial, which is at unit commanding officers level. Then little higher is a district court-martial, summary general court-martial, and lastly the general court-martial. A general court-martial can try any accused of any rank for any offence and can award any punishment, including death penalty. Insofar as jurisdiction of a civil judiciary is concerned, if required, where a soldier has committed a civil offence, he is also liable to be tried by a normal criminal court. The second part is that if a person has been tried by the military tribunal, then he gets one opportunity of appeal, and that is to the Armed Forces Tribunal. And insofar as higher judiciary is concerned, the fundamental rights, in case they have been curtailed, restricted, or denied, then a soldier can approach a High Court or Supreme Court under the writ jurisdiction. It would have perhaps appeared to you as to what are the reasons because of which court-martials are speedy in decision making. Well, the slide in front of you indicates that firstly, there is a motivation on an accused to plead guilty when applicable. So an accused, by virtue of the honor code, gets a motivation that, well, he has committed a fault and there is no point in his trying to shield or hide. As a soldier, he can stand up in a forthright manner and say that he has committed the offense and he is prepared to face the consequences which are there, and that makes the trial by court-martial speedy. These are ad hoc courts. They have no other work except to proceed with the trial against that accused on a particular charge sheet, and to that extent they are ad hoc courts. There is a system of defending officers provided under the army rules, and accused gets the service of a defending officer to defend himself, and this is an officer usually of his choice. Court-martials also have an accountability. They give reasons, brief reasons in support of finding, and their decision is subject to confirmation by an authority, which may be convening authority or higher, and therefore to that extent their decision provides for accountability. And lastly, there is effective monitoring of the passage of trial, so the administrative authorities keep an eye so that the trial should not just linger on. In the end, I would like to highlight that pendency of cases at trial courts in India can be addressed by adopting certain features of military law and procedures in other jurisdictions. This remark has been made having regard to a very frequently asserted, spoken, factual matter that there is a huge pendency in different courts in India. It is time, and that time will come to you once you have gone through the entire session on military law, the series. You would appreciate, and perhaps you would be induced to say that there are certain advantages in military law system And well, if they were to be brought back and transported to the civil side, maybe that this huge pendency would stand curtailed to some extent. Thank you.